number 4 and number 5? Oh, you said these are deleted? Yes. So you're stopping at 3? Yes. Okay. Honour members, I put the question that clause 12 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 12 as amended.
Put the question that clause 12 as amended do stand part of the bill. Those in favour say aye, to contrary no. Ayes have it.
Clause 13.
Clause 13, Honourable Chair.
Clause 13, we propose to amend it as follows. In subclause 1, by deleting the word person and substituting it with the words domestic or foreign supervisory authority or domestic law enforcement authority. 2, in subclause 2A, by inserting the words a domestic and immediately before the words in the case of a, and 3, by inserting new subclauses 3, 4, 5, and 6 immediately after subclause 2 to read as follows. 3, for the purposes of subsection 2A, the authority may require the domestic or foreign supervisory authority making the request to give a written undertaking in such form as the authority may require to provide reciprocal assistance to the authority. 4, a decision by the authority shall be made only where the authority A has received satisfactory assurances from the local or foreign supervisory authority that any information and documentation provided to it will not be used in any criminal proceedings against the person providing it, other than proceedings for an offense of perjury or any equivalent offense. The local or foreign supervisory authority undertakes to make such contribution towards the cost of exercising its powers as the authority considers appropriate. And C, is satisfied that the local or foreign supervisory authority is subject to adequate legal restrictions on further disclosure of the information and documents, and that it will not, without the written permission of the authority, 1, disclose information or documents provided to it to any person other than an officer or employee of the authority engaged in the exercise of any of its supervisory functions, or 2, take any action on information or documents provided to it. 5, the authority reserves the right not to provide the information requested. 6, the authority may share information with other supervisors and also inform them before taking any action that might reasonably be considered to affect group entities under their supervision, and where prior notification is not possible, the authority shall inform the relevant supervisors as soon as possible after taking action. Justification. To comply with ICP 3 that mandates the supervisor to have the legal authority and power at its sole discretion and subject to appropriate safeguards to exchange information with other relevant supervisors. The existence of an agreement or an understanding on information exchange is not a prerequisite for information exchange.
Now, Honorable Chair, I want to be satisfied about this issue of person, because person may be human or corporate. Now, when you say it's only a domestic or foreign service authority or a law enforcement authority that can request for, if I'm an individual, can't I apply this authority to get information?
Madam Chairperson, this amendment is aimed at ensuring that disclosure requirements are provided for, and the regulator has got all avenues to ensure that he gets the required information. So my view is that if this is to be an individual should be required to give information to the authority, not the other way around. And that's why we are using person to mean the authority or any other corporate body.
I don't know. So, me an individual cannot request for information from that authority. I must be a domestic or foreign supervisory authority or a law enforcement. Me an individual, I cannot ask for information from the authority.
Madam Chairperson, even an individual can ask for information. An authority can avail information to all stakeholders, including individuals, because most of the policy holders are individuals. So they should not be limited to access to information.
So, in that case, you don't need to delete the word person. I think you need to just add domestic or foreign supervisory authority or domestic law enforcement to add, so that the person, me, an individual can ask, but the authorities can also ask,
Okay.
instead of deleting.
Okay.
So I think let's just add.
Okay.
Add the words domestic or foreign supervisory authority or domestic law enforcement authority. After person, comma, person, comma, then
This
domestic
is,
or foreign.
Madam Chairperson, I can be helped by someone to, if
Okay,
someone
let's do
can-
this. The authority may, on the written
draft it
written
better.
request of any person, comma, domestic or foreign supervisory authority or domestic law enforcement authority, undertake on-site inspections, etc., etc.
No, it's consulting.
Madam Chairperson, the head note of the clause is dealing with cooperation with authorities, not persons. And in this regard, I feel the amendment does not hold.
Well,
The amendment being proposed by the House.
Chair, Honourable Minister, what was your rationale for this provision in the first place?
Madam Chair, I think we need to refer to the head note under 13. It was referring to the power to cooperate with other authorities, not necessarily talking about information as you are suggesting. So if we look at the head note, then the body and amendment proposed by the chair become relevant.
So only these authorities can ask for information. Okay, I put the question that clause that you have spoken to all the others. Okay, I put the question that clause 13 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 13 as amended.
Put the question that clause 13 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 14.
14, Honorable Chair.
Madam Chair, we propose that clause 14 be amended as follows. In subclause 2A, by A, deleting the words Institute of Uganda and substituting the words Training College in paragraph D. B, paragraph D, 2D. Are we clear?
Is your text different?
No, I am,
Are you amending?
this is the further,
Okay,
this is the new development.
okay. So you have amended this. It is not as appearing in this text.
By inserting new paragraph H and I immediately after G to read as follows. The Chief Executive Officer of the Capital Markets Authority. I, the Chief Executive Officer of the Uganda Retirement Benefits Regulatory Authority. 2, by deleting subclause 3 and substituting it with the following. 3, the chairperson and the persons referred to in subsection 2F shall be appointed by the minister from among persons who have knowledge, experience, and skills in insurance, banking, finance, and actuarial science. Justification. The Insurance Institute of Uganda is to be transformed into the Insurance Training College with the mandate to train on insurance. 2, to provide for a representative of the Uganda Retirement Benefits Regulatory Authority and Capital Markets Authority to be on the board. 3, to give the minister powers to choose a chairperson and 2 persons representing the public from persons who are qualified in insurance matters, banking, finance, and actuarial studies.
Clarification, Honorable Barimuzi.
Thank you very much, Madam Chair, and I thank the Honorable Musasizi. I just have 2 points of clarification. The first one is that usually when we are passing boards in this House, we provide for a figure of 9. Seems to be the standard policy of government, of 9. So I just wanted to know, with the inclusion of new members, how big is the board now? I'm saying the policy of government has been to constitute a board of 9 members. And now you are adding new members. I don't know what is the new number of the board members. Then secondly, Madam Chair, the chair of the committee gave a justification. He said the Insurance Institute of Uganda is to be transformed into the Insuring Training College, as if the training college has not yet been established. So would it be proper for us to put it where it's not yet created? Because I'm saying it is to be transformed, meaning it is in the future. And we are anticipating something which hasn't happened. Would that be proper? Wouldn't we wait for the creation of the training college? Then if it requires amending the law, that's when we can insert it, instead of putting it up front.
Can I
Honorable-
first respond to his?
Asama? Osama and then Honorable Mutonyi.
Madam Chair, on the representation of the two people from the public, I think we'd be interested to have the users than having all the skilled people in insurance. Because in the public, we, the people who are going to use the insurance services, maybe could be picked to be part of the board than just having all the experts. Because when you look at the others, they all have something to do with the insurance. The Ministry of Finance, Bank of Uganda, Insurance Institute, then the health, maybe to know the issues of health. But then the users, how do we support the consumers of insurance? Thank you.
Honorable Mutonyi.
Thank you, Madam Chairperson. I was wondering, is it an assumption or, because I'm looking at F, 2 persons representing the public, one of whom shall be the deputy chairperson. Now, why did they leave out the woman? Or it is assumed that... Where? Oh, okay. Thank you.
We have an answer to that?
For me, I was after the 2 persons representing the public. They have said one of whom shall be the deputy chairperson. But I was also thinking that they could add, and one should be a woman. But I've been told that gender is somewhere there. But why don't they put it there? One of whom should be a woman, apart from deputy chairperson.
14.4.
It is 14,
The minister shall, in appointing the members of the board, ensure that there's a balance of skills and gender.
14F.
14.4, 14 subclause 4.
Yeah, 2F.
14.4 is provided for. Can you answer on the issue of the numbers?
Madam Chairperson, the issue of the numbers, we are proposing 9 board members with voting rights, and this is consistent with the government policy as Honorable Bajomunsi suggests. The 10th one is the CEO with no voting powers. And on what? What is the
The training institute in the
on
future.
the training institute, Madam Chairperson, currently we have the training institute in Uganda, and this bill is proposing to transform it into a college as a result of the benchmarking studies we have conducted. So, Madam Chair, maybe if, yes, it is created by law, the Insurance Act of 2006 as amended in 2011 established the Insurance Institute. And
But can we just
maybe-
change it casually?
sorry?
Can we just change it casually? From an institute to a college?
It,
It must be done by law, by an act of parliament.
and we are proposing, in this bill, we are proposing that the institute be turned into a
Where is the
college.
proposal?
It is, I need to,
Honorable Saida? Yes, Honorable Saida.
Yeah, Madam Chair, under clause 137, there is the establishment of the Insurance Training College. But my worry is, if we pass these earlier clauses referring to a training college which is not yet created, shall we not be legislating in anticipation? Is there a way to bring this creation of the insurance college earlier?
But if you read subclause 137(2), purposes of subsection 1, the Uganda Insurance Institute existing immediately before the commencement of this act shall be transformed into the Insurance Training College. I think it's in the plan. So when it is transformed, it will cease to be an institute. So then I think we can do it. I think we can do it. We can take it. Okay. Anything else, Honourable Members? Honourable Minister.
Make a slight amendment on 14C.
See?
Yes, it reads as the governor of the Bank of Uganda, not a representative of the governor.
You suppose the governor is not there. We cannot delegate? If the governor
We
is not
either
there,
say
he
the
cannot
governor
delegate.
of the Bank of Uganda or a
is
representative
I
of the
think
Bank of Uganda.
Yeah.
Maybe.
The governor of the Bank of Uganda who is representative.
Yeah.
Okay. I think let's amend it like that. Anything else? Yes, Honourable Samu.
Replying mine, because I wanted it to remain the way it is. 2 persons representing the public, one of whom shall be the deputy chairperson, and whatever it is ending there, than having the things of skills, expertise, and whatever. We will leave this to the one who will be appointing the people. Thank you.
You don't want the skills and expertise?
Madam Chairperson, this law is aimed at improving the ways of doing business in the insurance industry. And insurance industry is specific. That's why the issue of skills, the issue of experience must come out, because we are dealing with a specific sector with a specific
No, but I think
requirements.
Honourable Asamo has a point. The experts are there. That's the Ministry of Finance, Commissioner, Governor of Bank of Uganda, someone from the Training Institute, someone from Health, but these are from the public. They can get the chairman of Casita because it's from the public.
To mobilize for them those customers.
Madam Chairperson, Uganda has evolved. Even in Casita, we have these skills there. In the private sector, these skills are there. And therefore, it's not that we will be restricting the public from accessing the board. As long as we can get the skills from Caseta, why not? Experience does not necessarily mean that one must have gone to school to do a course in insurance. But he may have practiced insurance as a broker, for instance, or an agent for quite some time. And I believe this experience can be got from the public, Madam Chair.
Don't you need some civilian brains? Yes, Honourable.
Madam Chair, my understanding of Honorable Samo's submission was that the other institutions, including ministries, are sending their technocrats. Although there is a provision for balancing gender, I think she wanted that specifically the 2 persons who will represent the public, we balance them. At least one of them should be a female. If I got her properly.
No, her worry was the
Yes.
qualification of the members. She was saying that the qualifications will lock out members of the public.
There I didn't agree with the chairperson. This is a specialized area where you require people who have skills in insurance.
Madam Chair.
Yes, Honourable Samu.
Madam Chair, you know, insurance in Uganda is very poor because people don't understand it. So if you don't have somebody there to learn what is happening there, even me, I can be the public. And I don't have any knowledge about insurance. But I can come back and talk to members and say, please go and get insured. You know, this person is like a person coming from the public, well established, has integrity, but his work or her work will really be to tell you what is the views of the public about insurance. Whereas the rest of the members have the knowledge. You understand what I'm saying? Yeah.
Honorable Bala, then Abut.
Thank
With Abut.
Madam Chair, thanks so much. I have a problem, and my problem is about the word public. How do you define public in this context? Because all the ministries, what is being defined here? Bank of Uganda is a public, Ministry of Health is a public, Insurance Institute is a public. I would propose in that case that let the public, let's have a private sector, two from private sector, to take care of that bit. Otherwise, we shall take a long time debating on something that we may not understand. Thank you.
But public sector is the public service. That would be still civil servants. Honorable Abbott, and then the minister. Okay, Honorable Wirike.
Right Honorable Speaker, I'm on F, where we have two persons representing the public and one of whom shall be the deputy chairperson. I think having the experts from the public would actually make a contribution, because we really need to have people who understand, because this is a professional area. If we just send people there who are not actually experts, there might be actually no meaningful contribution, and therefore we may just have people who will be spectators on behalf of the public. So we would rather have actually experts. I concur with the chairperson, Madam Chairperson.
Honorable Bangura.
Thank you very much, Madam Speaker. I would concur with Honorable Asamo. Insurance is not doing well in Uganda here because our people are not informed. Whereas we need the experts to be there. But the biggest challenge now is with our business community, who would be the first beneficiaries of this. I would instead, I know there is expertise developing even in the private sector who may be considered the people out there. We have the logistics industry, we have the catheters. They should be able to get us the best of their best. And those will be the people who will be interacting with the people who fear to get into insurance business today.
Also, honourable members, when you have just the the so-called experts, they may not understand the public environment. You know, in the court, we have assessors. They are not lawyers, but they sit there and they also give their opinions. You may take it or you may not take it. I think this is for the people. I think we should find a way where the people's interests are. You know, the experts, these doctors will just prescribe medicine, but the civilian may give you some views. A villager from Kanungu.
Thank you, Madam Chairperson and colleagues. I think we can have a middle ground, because if you read 3 and 4, the chairperson and the person referred to in subsection 2F shall be appointed by the minister. That's what Honorable Helen is proposing. And then 4, in case there is a need to have particular skills in appointing those two, 4 suggests that the minister shall, in appointing members of the board, ensure that there is a balance of skills and gender. So I think her proposal does not necessarily harm the spirit of the objective of the bill. So I concede to her proposal.
Thank you very much. Put the question.
Close 14.
Clause 14 be amended as proposed variously. Those in favor say the contrary, no. Ayes have it.
Close 14 as amended.
Put the question that clause 14 as amended do stand part of the bill. Those in favor say the contrary, no. Ayes have it.
Close 15.
Clause 15, Honorable Chair. Honorable Chair.
Madam Chair, we have no amendment in clause 15.
You have abandoned the traffic offense? There's something, I think you wanted to put an exception.
Okay. Clause 15 be amended. We propose that clause 15 be amended as follows. Except a traffic offense immediately after the word offense. Justification: traffic offenses are minor and should not be used to disentitle one from being a member of the board.
I think we need to refine it by saying has been convicted of an offense other than a traffic offense, not to accept a traffic offense.
Madam Chairperson, I have no problem with that.
Okay. Honourable members, put the question that clause 15 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Close 15 as amended.
Put the question that clause 15 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Close 16.
Honourable Chair.
Clause 16, Madam Chairperson, we propose to amend it as follows. By deleting subclause 1 and substituting it with the following. 1. A member of the board shall hold office for 3 years from the date of appointment and is eligible for reappointment for only 1 term. 2.
No other term.
Is eligible for reappointment for 1 further term.
So what you're adding is from the date of appointment?
Sorry?
What you're adding is the 3 years from the date of appointment?
A member of the board shall hold office for 3 years from the date of appointment and is eligible for reappointment for only 1 term, meaning that you can be in the board for only 2 terms.
I think you still need the word further. Because,
Sorry?
you know, this one can confuse you. It may confuse you and say remain there for just 1 term. I don't know why you don't want the word further.
Madam Chairperson, Madam Chairperson, I think this is a matter of drafting. I have no problem with using the word further. Can be in the board for 1 further term.
Okay, okay. Okay, then you had
Then,
2 more.
2, in subclause 2, by deleting the words chairperson and by deleting subclause 3 and substituting with the following. A member of the board may at any time resign from his or her office in writing address to the minister, giving notice of not less than 1 month. 4. In subclause 4, A, by deleting the word or appearing in the last line in paragraph F, by inserting the word or immediately after the word minister appearing in the last line of the paragraph in paragraph G, by inserting a new paragraph H immediately after paragraph G as follows. Where any of the grounds for disqualification under section 15 becomes applicable to a member subsequent to his or her appointment. 5, by inserting after the new paragraph H the following subclause 5 as follows. If a member of the board is or becomes aware that any of the grounds for suspension or removal specified in subsection 4E, F, G, or H apply to him or her, the member shall, within 15 days, give written notice to the minister and the chairperson, or if the member is the chairperson, the deputy chairperson. Justification: to require notice to be given in writing.
Honorable Samo, then Honorable Karungi.
I'm looking at the members who represent institutions in case their tenure ends in the institution. Then their term of office also expires. So maybe we needed to put somewhere that there are people who are here, like maybe, let's say, okay, maybe a commissioner or governor of Bank of Uganda, and maybe he's not yet there. He cannot continue being a member of the board when he's no longer the whatever. So I don't know how we can put it somewhere.
Madam Chair,
Honorable Karungi.
further clarification. Thank you, Madam Chair. This subsection 2, Madam Chair, the clarification I'm seeking is, are we deleting it? And secondly, I think it also needs to be made clear the term of office, when it will start and end. It is not clear to me.
I think he made an amendment to that one from the date of appointment. We have made an adjustment, yes. We have done it already in 16.1.
Madam Chair, the clarification being sought by Honorable Helen, I don't think it is necessary to state that a representative of the governor, if his term of office expires, then he is no longer a member of the board, because these offices don't expire. The member representing the institution can cease to be an employee, but the office will not expire. It will remain. Yeah. So whoever comes in automatically will be on the board.
Okay, honourable members, the question is that clause 16 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 16 as
The
amended.
question is that clause 16 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 17.
The question is that clause 17 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 18.
18, Honourable Chair.
Madam Chair, we propose to amend clause 18 as follows. 1, by deleting subclause 2A and substituting it with the following. A, advise government on policy matters concerning insurance. 2, in subclause 2B, by inserting the new words, establish the principal policies of the insurance, policies of the authority, and immediately before the word oversee. Justification: to make the provision more clear and to make the establishment of the principal policies one of the functions of the board.
Now, Honourable Chair, who will assist the government to do the implementation if you remove coordination and implementation of policy relating to insurance? Because you want to stop at the advise government on policy matters concerning insurance only. Who is the implementer of the policies?
Madam Chair, we are establishing a board and the authority which has management. There is a CEO to together with the staff, which I can call the secretariat. This secretariat is an implementer of the board decisions and policies.
Honorable Minister.
Madam Chair, I think we need to convince the chair to maintain this clause the way it was, because the point you are making is that in A, we see that the board is being given another assignment to coordinate the implementation of government policy relating to the insurance, because the secretariat are actually the employees of the board. So it is the apex of the institution. So I think the way it was, including coordination, I don't think only restricted to policy. I think it is okay.
You don't agree, Honorable Chair?
Madam Chair, I concede.
Okay. Okay, then we go to, yes, Honorable Rakojo.
Thank you, Madam Chair. I propose that 18.1 should read, "The board shall be responsible," instead of "is responsible." Because when we say "is responsible," it's like we're telling a story or something like that, but we need to really give it effect. Aware about 2, which says "without limiting the general effect of subsection 1." So it's general, but here it's like we are giving a narrative or something. Thank you, Madam.
Do you have objection there? No objection.
Madam Chair, I have no objection on the proposal by Honorable Robina.
Okay, Honourable members, the question is that clause 18.1 be amended as proposed. Those in favour say aye, the contrary no. Please have it.
Clause 18 as amended.
Put the question that clause 18 as amended do stand part of the bill. Those in favour say aye, the contrary no. Please have it.
Clause 19.
The question is that clause 19 do stand part of the bill. Those in favour say aye, the contrary no. Please have it.
Clause 20.
Question that's clause 20 do stand part of the bill. Those in favour say aye, the contrary no. Please have it.
Clause 21.
Honourable Chair.
Clause 21, Madam Chairperson, we propose to amend it as follows. By inserting a new clause, a new sub-clause 6 immediately after sub-clause 5 as follows. The minister shall publicly disclose the reasons for disqualification or removal of the chief executive officer. Justification: to comply with ICP 22 that provides that there should be explicit procedures regarding the appointment and dismissal of the head of the supervisor and members of its governing body, where such a governing body exists. When the head of the supervisor or members of its governing body are removed from office, the reasons shall be publicly disclosed.
Members, the question is that a new clause. Yes, Honourable.
Madam Chair, I find this a little bit strange that the minister has to sack somebody either through television or radio. When I see the justification seems not to tally with what you are recommending. The justification is just saying ICP 22 says there should be an established procedure. So I would oppose this, because my understanding is that you are saying that the minister should announce to the public that I have sacked so and so. Would it be unfair? Is it really the requirement of ICP that?
Suppose I continue holding out. They sack me and I continue holding out. What happens? No, let's find a
If
solution.
it takes action, I'm sure he does it in writing, and once you receive a letter that you have been discontinued, there are mechanisms internally to make sure that you no longer hold the office. But what I'm objecting to is
The public.
going public on radio and television and so forth.
Honorable Chair.
Madam Chairperson, this amendment generated a lot of debate in the committee. But we were advised that this is a standard requirement. And
In the industry?
yes,
Standard requirement in that industry?
when you look at the justification to comply with ICP 2.2. So this is just a compliance requirement, Madam Chairperson.
I think what this CP22 requires is that the procedures be clear for recruitment, for appointment, for dismissal. They should be laid out, not that they should be announced to the Vachiga. Yes, Honorable Member, Genasio.
Madam Chairperson, my name is Genasio Maramye. Why the committee chose it that way to announce was to prevent future people who would want to default or to defraud. Because when you announce that someone has been sacked for a particular reason, then it becomes better for the public to know that the person was disqualified because of behaviors which would not be appointed to another office. Thank you.
Yes, Honorable Barbara.
Madam Chair,
Yes, Honorable Barbara.
I am worried if we take it like that. I'm very worried. The worry is we have to announce that so and so has been appointed in the first instance. Then in the second instance, we must also announce when we sack him. Now that causes a bit of problem. Even within the institution, you are going to have chaos because the element of professional code of conduct, I don't know what it actually involve. My view is we would actually leave this sub-clause out as to maintain the whole arrangement. Thank you so much.
I don't know. Oh, you- Yes, Honorable Sam, you read this. There's something. Yes, Honorable Sam.
Madam Chair, I wanted to make the reference, when the chief executive is being appointed, is on the recommendation of the board. And the board played a role of a supervisory role of the chief executive. In fact, the minister will not be supervising this chief executive. So I think the sacking should be on the recommendation of the board, having seen that he has not fulfilled these terms and conditions of work. Then they can write, and then the minister can use that to fire. But announcing somebody, you kill the whole family and the whole clan and everybody. There could be a company which can take me, and maybe there are different terms the other side. So I would think the board could play a key role of recommending the sacking of the chief executive than again saying we just make an announcement by the minister just sacking without the board. The board's role is not indicated in that paragraph 5.
Honourable members, what other industry publicly states the dismissal? What other industry? I want to know if there are other industries where this happens. Are those binding? Are those?
Madam Chairperson, why we are repealing the old law and replacing it with this new one, largely, substantially is to comply and conform to the requirements of the insurance core principles. And Madam Chairperson, why there are deadlines that we must have this law is going to be evaluated by the association, the World Association, to assess whether it conforms to the standards. And therefore, some of some of these proposals,
Clarification,
it's
Madam
unfortunate
Speaker.
that we are just importing them from the standards and putting them in.
Clarification, Madam Speaker.
Point of clarification, Honorable
Thank you
Karume.
very much. Madam Speaker, I thought that we make these rules, of course we must conform to the standards, the minimum standards really. If the law maybe we had somewhere does not really befit us so well, do we have to conform to that because we are going to be maybe looked at by other people, or other companies or other countries? Do we need to, you know, to make our laws in that regard, really?
Madam Chairperson, Uganda does not exist in isolation. And we have to, as much as possible, try to fit within the global perspective on how some of these sectors are looked at, including the insurance sector. I know it's difficult to justify before the House, but this is a requirement I find myself constrained to defend, but which I must defend,
But-
because we must.
Honorable members, have we domesticated this insurance ICP? Have they been brought into this country, adopted by this House? Are they part of our law? Yes, Honorable.
Madam Chair, there are two, in law, I'm not a lawyer, but I've learned some law. There are two areas in the international law. Is what we call legal monism, where instruments which are agreed upon, whether regionally or internationally, can directly have an effect of law at country level. But for us in Uganda, we have legal dualism, where instruments that are ratified can only have effect through domestication. And this is like part of the process to domesticate that. But domestication through legislation, in my view, doesn't necessarily mean you must transplant whatever is in the instrument into the municipal law. It depends on what Parliament feels, and I don't think we are obliged to just photocopy whatever is in this. So we can uphold the principle as captured in that provision of having explicit procedures, but I don't think we must have that provision of public declaration. Let me give an example. In 21D, it says the CEO can be removed from office by the minister on recommendation of the board for incompetence, inability to perform the functions of his or her office arising from infirmity of body or mind. Supposing the CEO gets an accident and is infirm, and then the minister is going on TV to say, today I have publicly sacked so and so, you ruin his family, when actually the reason for sacking him is not to do with the moral turpitude or corruption or so forth. So, my view is that we don't have to insert everything. And even if we omitted that provision, still we shall have complied with the general principles of this instrument. Yes. And we have always domesticated very many instruments here, but we don't have to necessarily put everything. We just try as much as possible to see that we comply with the general principles.
I think the only one where we took almost everything was the COMESA Treaty.
Yes.
And we only added, we made some small amendment, which was outside the COMESA. But do you see a situation where someone can hold out after being sacked? Can you go continue driving to the office and sitting there would have been sacked?
Madam Chairperson, this amendment is seeking to protect the independence of the people charged with this responsibility. You have two important institutions here, actually offices. One is the board, and another one is the office of the CEO. What this proposal is seeking is that if by any reason they are terminated, then the public should know the reasons why they have been terminated. This is what the amendment is seeking.
I don't know.
What we lose, I can take the clarification. What we lose, Madam Chairperson, these two offices are responsible to the public. We need to understand the insurance sector. The insurance sector, actually the insurance business collects money from the public, and this money is given to companies. Companies keep it on a promise that they will compensate in an event loss occurs. So the policyholder's protection largely lies in the regulator. And in the regulator, we have a board and a CEO. What this means, if a regulator is mismanaged, then public interest can easily be lost. So our view is that in order to give maximum protection to the people charged with governance responsibility, we should make whatever they do public, and whatever happens to them should also be known by the public
Madam
whom
Speaker.
they protect.
Clarification.
Yes, clarification.
No, okay, clarification.
I just wanted to be guided. Does the CEO of the authority run the day-to-day business of the insurance companies?
Thank you, Honorable Frederick. The CEO of the authority does not run the day-to-day business of the insurance companies, but is charged with the responsibility of licensing and regulating all insurance sector-related businesses.
No, Babot. And then Ababi.
Madam Chairperson, we are aware that there are procedures, very normal procedures, in appointment and dismissal of civil servants or public officers. These appointments and the clarifications are really made that when I have a problem and I've been dismissed, reasons are given. And when reasons are given, when I have a complaint, I follow the normal procedures, but we don't speculate that when I'm going to be dismissed, maybe I'm going to refuse in the office. With me, what I know that the procedures, so long as they are there, I've been dismissed, that is the end of it. And if I want to follow, the public can go and read why I was removed from office. They are there if I want to complain.
Maybe, let me ask Honorable Chair, what is the public notice? What do you envisage in a public? Is it in a newspaper? Don't deal with this man, he has been sacked. Do you cause a press conference? What is the message in public disclosure of this sacking?
Madam Chairperson, we want the...
Which public are you talking about? Is it my friend in Backyard? Is it how far is the... I'm trying to understand who this message is intended for.
Madam Chairperson, this message is largely intended to the public whose interest is being protected by this regulator. And these are policy holders. So they should be informed.
They should know that I should not deal with you again.
Yes, this is what we are trying to do. deal with.
Now, anyway, when they appoint me, do they announce in the radio that we have appointed so and so? I don't know. Oh, anyway, okay. When we Katsabe, then
Thank you, Chair. My understanding is there are procedures for appointment, promotion, dismissal, and other things. And Chair, I think when it reaches to the issue of dismissal, it is not done haphazardly. It is done in a prepared manner. First of all, they even provided here that an opportunity will be given to that person. There's going to be an interaction, and by the time one is written a letter that Ababiku, you have been dismissed, there are administrative conditions that will be provided for even handover of the assets of such a board. Therefore, I feel we should not really continue having this issue of having it put in public, but should be handled administratively, whereby the security of the assets or the operations of that person will be regulated through a clear process. Because what you are intending to cure here is a fear, probably that one may take that opportunity to go and continue with the businesses as usual when the person is already dismissed. But I think that can be regulated internally. Thank you.
maybe it's because it's also the accounting office. I don't know. Yes, Honorable Minister.
Madam Chair and colleagues, yes, it is true these regulations provide that there are explicit procedures regarding the appointment and dismissal of the head of the supervisor and members of its body. If such a governing body exists, when the head of the supervisor or members of its governing body are removed from office, the reasons are publicly disclosed. But I still think that we can move the way we had suggested in the bill, but take care of some of these things in the regulations or human resource manuals, and all this will be part of the governance of the body that I think collectively, this world governing body, if they are to assess us, they will look not only at the principal law, but also other manuals that are governing us. So to put this one in the principal law, when we are not sure which audience, which public we are talking about, what method are we going to, how are we going to, because we can injure this person and stuff like that, we would rather, I suggest to the chairperson to concede and we leave the law the way it was, and then we'll take care of some of these things in the human resource manual and the regulations of the law.
Let's move. Madam Chair. Let's move.
What
Madam Chairperson.
do you have a proposal?
Yes.
A win-win proposal?
Madam Chairperson, since the minister has committed to take care of our wishes in the regulations and the manuals, and also looking at the mood in the house, I concede.
Okay. Honourable members, the question is that clause 21 do stand part of the bill. Those in favour say aye, the contrary no. Now there's no amendment. We are staying with the old text. Yes. Yes, Honourable Bina.
Madam Chair, I wanted to agree that because in our law the conventions and all that are not self-executing, we have to domesticate. But we do not have to take on everything that is therein, that we leave it as it is. Especially, you normally find that they will rhyme. If appointment is public, then dismissal will be public. But what I know is what you have not provided for in the main law, you cannot provide for in the regulations if it is something that important. So we shouldn't think that because the minister has promised, it will be taken care of in that regard. I think we just realize that we won't have it all together.
But, honourable members, this is a nascent industry. If I'm to see that clause there that, you know, you'll be dismissed publicly, I'll not apply for that job. I say, Sagara. If I'm going to... Oh, sorry. Yes.
Madam Chair, I'm privileged to sit in as a LOP this afternoon. By designation. First of all, I want to thank the chairman, for this very excellent. And also, I want to really use this opportunity to reinforce what the minister has just mentioned. You see, a CEO, we're talking about a chief executive officer, an office that has dignity, and of course, international standards dictate that whoever really sits in or gets the job as someone that will come with dignity along. So, to me, it would be redundant, Madam Chair, to have the public sacking incorporated or to make it a part of the bill. You're not talking about the marketing officers. Like we see those things in the print media. Notice, so and so no longer works with us, and whoever continues to work or relate with them does so on the... We're talking about chief executive officer. And Madam Chair, it is a standard international practice that a public announcement did not. Because even when they apply for other jobs elsewhere, as long as they have mentioned that they have ever served at that level, then the employer or the prospective employer takes it upon him or her to dig out what could be the history that relates with his time at the service of the previous employment. So, Madam Chair, if you can, I think we should stay the other one and take it as it is. Thank you.
Honourable members, I think there are enough reasons for which someone can lose a job. They're here. We don't need to add injury to say we shall put in the notice. We don't like this man. Be careful with him. Hey, you know. Okay, honourable members, I put the question that clause 21 do stand part of the bill. Those in favour say aye, the contrary no. I serve it.
Clause 22.
Put the question that clause 22 do stand part of the bill. Those in favour say aye, the contrary no. I serve it.
Clause 23.
Put the question that clause 23 do stand part of the bill. Those in favour say aye, the contrary no. I serve it.
Clause 24.
Put the question that clause 24 do stand part of the bill. Those in favour say aye, the contrary no. I serve it.
Clause 25.
Put the question that clause 25 do stand part of the bill. Those in favour say aye, the contrary no. Clause 26, Honourable Chair, I think you have something. 25? No, I don't see it. Where is it?
There was
25? Oh, 25. Yes, Honourable Chair, there is something. Honourable Chair. Page 17.
25.
Notwithstanding anything contained in the Public Finance Management Act,
16 going to 17.
all monies under subsection 1 etc. received by the authority shall be retained by the authority and used to offset costs of administration and other expenditure? How?
Madam Chairperson, I propose that I first read the amendment, then I can justify it. Madam Chair, we propose to amend clause 25 as follows. By deleting subclause 3 and substituting it with the following. Notwithstanding anything contained in the Public Finance Management Act 2015, all monies under subsection 1, C, D, and E, and F, received by the authority shall be retained by the authority and be used to offset the costs of administration and other expenditure. 2, by deleting 4, justification, subclause 4 is incomplete and redundant, and the justification for the previous proposal or amendment is to give
25.
the authority powers to retain the levy it charges from premiums.
I don't know. I hope you can really satisfy us, because we have been consistent on this matter, that all monies should go to the consolidated fund first and be appropriated by this House. So I don't know how you are.
Madam Chairperson, how the insurance regulatory authorities work world over is that they levy an amount of fees on the premiums charged, and these monies are the ones they use to run their day-to-day activities, and these are the same monies they use to run their operations. The Insurance Regulatory Authority of Uganda, under the old law, has got this mandate. It never gets any money from consolidated fund. It is run by the monies they charge on levies on premiums, and we are seeking to maintain the status quo. Madam Chair,
No.
this is not a new development.
In 25A, why didn't you attack 25A? It says money appropriated by Parliament for purposes of the authority. Now you are saying they don't get money from the fund. But this is the proposal. Then why don't you say levies? Why are you saying all monies? Because you are now dealing with all the monies. You are saying all monies received should be.
Madam Chairperson, maybe this was an oversight by people who prepared this bill. But in essence, the regulatory authority is run by the levies charged on premiums. And I don't think there is any other form of money that comes to the authority, apart from premiums and licensing.
So we shall not appropriate money.
No,
Not even to start it off.
no.
We shall not appropriate any money? Not even to give them a push?
But Madam Speaker, we have to change this. We should change it. And secondly, on that note, I'm even wondering, Madam Speaker, I'm wondering, this subsection 5, which is saying that the authority is exempt from the payment of corporation tax. I don't know why, Madam Speaker. Every every authority in Uganda pays tax. Even members of parliament will pay tax. Everywhere, everybody pays tax. So, the authority also needs to pay tax. And Madam Speaker, like I had said, we should not carry everything from wherever other countries and bring it here, because we have to do it because others do it. If it doesn't befit us, if it doesn't help us, we should change it.
Yes, Honorable Babari.
Yeah, thank you so much. Now, I am referring to that clause 4. According to this one, it said that authorities should actually be charging fees, charges and contributions. Now, according to the new amendment, that all this should be discarded off. In embassies, Madam Chair, we are getting monies. Everywhere, including primary schools, they pay money to government of Uganda. Now, the authority here, we are exempting it, which is unfair. Madam Chair, information is that last year we lost $52 million to the Kenyan companies, insurance companies, and just because we are too generous. Like in, you look at 5 here, talking about that. Are we a charity in this environment? Are we a charity now? My view is we stay for the way it is.
But even the way it is not what we have been doing. Can we stand over it? Because we have been very consistent on this one. I don't think we can make exceptions without proper advice. Let's stand over it.
Maybe as we stand over it.
Yes.
As we stand over the clause, just maybe a clarification, which you can check, because bills are accompanied by certificates of financial implications. Because we are saying that the provision 1A, we say we may appropriate money, is a new introduction. So were you satisfied that the fees and the levies will raise enough money to run this authority? Because as if you are saying, the appropriation by Parliament was put in error. So if we remove it, are you sure that the fees and the levies will be enough to run this authority? So you could check what the minister said in the certificate of financial implications and see what's there.
So, remember, let us stand over it. Let's stand over it. Let us examine the pros and cons. Okay, stand over it. Go 26. Close 26. On your chair. 26. You had a small amendment.
Madam Chair, clause 26, we propose to amend it by deleting the word authority and substituting it with the word board. Justification: the principles of corporate governance demand that it is the board that should have regard sound financial principles.
And the members, the question is that clause 26 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 26 as amended.
Put the question that clause 26 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 27.
27?
27, Madam Chair, we propose to amend it by deleting the word board and substituting it with the word authority. Justification: the authority is the organ that opens and operates the accounts.
The members, the question is that clause 27 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 27 as amended.
Question is that clause 27 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 28.
Put the question that clause 28 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 29.
Put the question that clause 29. 29? Yes, Honorable Saida.
Madam Chair, we have stood over clause 25 because we wanted to get clarity on 25A. That is providing money appropriated by Parliament. And in clause 28, we are subjecting their borrowing to Article 159 of the Constitution. And Article 159, sub-article 2, applies to government borrowing. This means that by passing this without resolving the other issue means that we are indirectly passing the earlier clause which we have stood over.
Honorable Bumba is right. Actually, we have outlawed this provision in other laws, the capacity to borrow. We have removed it in all the previous laws. They cannot borrow unless they have authority of this house. They cannot just go out and contract this. So this one, Parliament has to approve. Okay. Although the borrowing powers were removed, but we'll leave it. Okay, let's leave it there. Clause 29. Put the question. Clause 29 do stand part of the bill. Those in favor say aye, the contrary no. Those in favor say aye, the contrary no. Ayes have it.
Clause
30.
30.
I put the question that clause 30 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 31.
Put the question that clause 31 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 32.
Madam Chair,
32. Yes, Honorable Chair.
we propose to insert a new clause 32 immediately after clause 31 to read as follows. Publication of accounts by the authority. The authority shall publish its audited financial statements at least annually in a Ugandan newspaper with a wide circulation. Justification: to comply with ICP 2.7.2, which requires the authority to be transparent in handling of financial matters.
Now, members, you have the proposal. It's for purposes of openness. Does anyone have an objection to that new clause? Now, members, the question that the new clause will be introduced as proposed by the chair. Those in favor say aye, the contrary no.
The clause as added.
Put the question that clause as added do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 32.
33 now. There's an old 32. Okay, now the old 32. And of course, they will be sequentially adjusted. I put the question that clause 32 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 33.
33, Honorable Chair.
Clause 33, Madam Chair, we propose to amend it as follows. 1, by inserting the word or, HMO, immediately after the word insurer, wherever it appears. 2, by deleting subclause 1 and substituting it with the following. 1, subject to subsection 4, a person shall not carry on or purport to carry on insurance business, reinsurance business, or the business of an HMO in Uganda without a valid license issued by the authority. 3, by deleting subclause 2 and substituting it with the following. A foreign insurer shall not occupy or operate an office in Uganda without the prior written approval of the authority. 4, by deleting subclause 3 and substituting it with the following. Notwithstanding subsections 1 and 2, the authority may authorize the effecting of insurance with a foreign insurer in exceptional circumstances. By deleting subclause 4 and substituting it with the following. Subsection 1 does not apply to a foreign reinsurer that enters into a reinsurance contract with a licensed insurer or a retrocession agreement with a licensed reinsurer, or B, a foreign insurer that carries on insurance business in accordance with an exemption granted by the authority. 8, by substituting for subclause 6 the following. 6, a person who carries on or purports to carry on insurance business, reinsurance business, or purchase an HMO in contravention of this act is liable to a fine not exceeding 1,000 currency points. 9, by inserting a new subclause as follows. A foreign insurer that contravenes subsection 2 commits an offense and is liable on conviction to a fine not exceeding 2,500 currency points. Justification: to comply with ICP 11 that requires the supervisor to impose corrective and preventive measures and where necessary impose sanctions based on objective and clear criteria in regard to enforcement.
Honourable members, we had the proposals for clause 33. Honourable Rosmari, then Honourable Sechkubo.
Thank you, Madam Chairman, Madam Chairperson. On 33(2), a foreign insurer shall not occupy or operate an office in Uganda without the prior written approval of the authority. I find the word occupy redundant because you can occupy an office without necessarily operating. So I would like the chair to clarify why the word occupy and then operate are both used in that article.
Yes, Honourable Sechkubo, then we shall ask the chair to clarify.
Madam Chair, the business of insurance can sometimes take international dimensions. And the way the way 33(2) is being amended is being restrictive rather than permissive. And I'm surprised, knowing well the chairman and the background he has in the insurance business. Insurance, sometimes now that we have mega investments in the country, the local insurance companies may not solely by themselves be able to cover such mega investments. And they need partnership with international insurance companies. Now, when we put 33(2) the way it is, as Honorable Rachmali has intimated, a foreign insurer shall not occupy. Suppose they have a liaison office here, a coordinating office from where they liaise with other local insurance companies. I think what we need to restrict, if any, is on their transactions. That's why I would amend that by saying a foreign insurer shall not transact business in Uganda without a prior written approval, or you call it license of the authority.
No.
But
Honour members, it's important that the authority knows where you are and what you are doing and with who. You can't just roll in and the authority must know that you have got a partner who is foreign.
yes, Madam Chair, but when you put it that for you to occupy, the operation part is okay. But when you say you can't step in Uganda, you can't occupy an office, you can't occupy space. Now, Right Honourable Speaker, I think we are putting too much restriction. And as we make it operational, you'll find there are going to be
Yes.
Thank you, Madam Chair, and thank you, Honourable colleague. I think we should not be taking much time on the issue of occupy and operate. The issue is to promote local content and give the authority its full mandate to regulate issues of insurance and matters of profit and loss. Thank you, Madam Chair.
Now, honour members, there's something I want to say, which a letter which came from the Minister of Finance. Members, I received yesterday a letter from a copy of a letter from the Minister of Finance. He was writing to the Prime Minister, and it came because our Property Holdings Limited in Kenya sent in a text of a law the Kenyans made. No foreigner can own land in Kenya. We have properties there. So they're made in such a way that our properties will be taken over by the Kenya government because we are foreigners. Yes. It's only here where people play. The foreigner must tell us where he is and what he's doing. Why do you come in quietly? Let us know where you are and who you are.
Right, Honourable Chair. But insurance is basically to cover the risks. And the point I'm bringing forward is our local industry might not have the capacity. And I don't know how the chairman was looking at this. Yes.
Thank you for your concerns, Honorable Sechikubo. It is true there are risks which are so big to be underwritten by only our local companies, as you may call it, or companies registered in Uganda. But Madam Chairperson, why we are providing for reinsurance is to provide for companies to underwrite risks and share the burden as well. What do I mean? The reinsurance principle works in such a way that a company X can underwrite a risk, and when it feels that this risk is too big for it to handle, in an event of loss, it can decide to give a portion to other companies. And the law, Madam Chair, is not restrictive on whether these companies are local or national, regional, or even international reinsurance companies. And it also provides for reinsurance under a syndicate. A syndicate is a collection of companies joined together to do business. And nonetheless, Madam Chair, the issue at hand is that should these companies, when they are to operate here, should they be known to us or not? And the answer is, as long as you come here to engage in activities that can be defined as insurance business, we must know where you are and what we are doing there. And that's why we are providing that you should you should report yourself to the authority, and the process of registering you starts. So therefore, Madam Chair, I don't see any harm with the proposal. We are seeking the House to approve, and I beg that you put a question and we move.
Honorable Saida.
Thank you very much, Chairperson. Chairperson, I support the proposal. If a foreign company has intentions to do proper business, they should not hide. Let them be known where they are. And in addition to that, Madam Chair, we are all in mood to support and promote and protect local content. So we should take all the precaution which protects the local content. You see what is going on. Minister of Trade is fighting Chinese, who came in as investors and now trading popcorn. We should avoid those kind of situation now that we are better informed. And Madam Chair, in addition to that, in the interest of further protecting local content, I found the penalty provided to be too low. It's only $10,000. Insurance business is business which involves a lot of money. 2,000 currency points is 40 million shillings. And at the current rate, that's about $10,000. Really, to that kind of a penalty to a company which has come to deprive our people, I think is too low. It should be revised to at least 5,000 currency points, Madam Chair.
And honourable members, we should not be complacent. In which country do you just walk in and start doing business? How? You can't even rent a building. Oh, no, such cool.
Madam Chair, I just wanted to seek clarification from the chair of the committee that in the original bill, 33(2)(6), actually 33(2), you maintained what is in the bill. You said you are amending it, but basically you cut and again brought it back. It's just the same. But on 33(6), the bill, that's a section on offenses, a provision on offenses, and it gives penalties in terms of currency points and a sentence for a number of years. But the committee has removed that part of sentencing and just maintained only the money, the financial fines. What is the rationale of removing the imprisonment?
What do you say about the upgrading the currency points? Honorable Saida was proposing that you enhance the currency points.
Madam Chairperson, I have no problem with the currency points being raised to a proposal as proposed by Honorable Saida Bomba.
So, because 5,000 currency points. And why have you removed the imprisonment?
Madam Chairperson, this law is not only aimed at prohibiting people from doing business, but is aimed at creating an environment where people can easily do business. So if someone has been fined and has agreed to pay the fine, we have a feeling this person should be let free to continue with his business engagements.
Do you know what he would have done? You are now thinking that the offense would be so light that a fine is enough. Eh? So, honour members. Yes, no, sir.
Mr. Chair, thank you, Madam Chair. Mr. Chair, I ask that we stay the imprisonment element, because what the purpose that is supposed to serve is deterrency, to deter. But if you begin now just putting 5,000, there could be loose change, and that won't deter the culprit. I think what we're trying to do is to put a clear check system, that you see every action will have a consequence, that you won't just play around, that you can have the freedom to choose your action, but certainly in Uganda, you won't have the same freedom to choose the consequences of your action. This is basically what we're trying to. So I request that we have both concurrently, the currency and also the imprisonment.
Okay, Honourable Saida, you wanted the 5,000 to be in 6 and 7? The 5,000 currency points? 6 and 8 and 9?
Madam Chair, I wanted the raised currency points to be under 6.
Where there's 1,000?
Yeah, where there is 2,000.
120?
Yeah.
Where there's 120? So we make it 5,000?
5,000 currency points.
Okay. On the currency?
On the same. Madam Chair, you know the dubious people in this world, they will try to use that as a way to do what they want. Because when you look at it, 5,000 currency points, that's less than 50 million. And 50 million to them is not money. My opinion in this case would be, we should be talking about 20,000 currency points. So that somebody knows you make a mistake, you're in danger.
That's how much? $40,000. You are contravening the act. You are contravening the act.
Madam Chairperson, whereas we appreciate the proposals being brought in by members, I would pray that we keep them within the confidence range. Because why this bill came to the committee was that we needed more time to study it and understand it further. So if somebody comes with a proposal that is completely far away from what the committee thinks is reasonable, I would think that Madam Chairperson will be given time to first understand it and study it better so that we assess the implications. No, Madam Chair, we have to move. Honorable Saida Bumba had brought a very good proposal. As a committee, we have no problem with it, and I beg that the House passes it and we move on.
Yes, Honorable Chin.
Madam Chair, the purpose of this law is to create an environment which can deter people from going overboard. In this country, most of these people who smuggle these drugs use our country as a transit route because we have got a law which is very relaxed. They know once you are caught, you are only fined some little amount of money, and they have this money. That's why they keep using us as a transit conduit route. And in Madam Chair, we have the oil. People are looking at the oil industry. And in oil, there is a lot of money. These insurance companies, especially for the reinsurance business, most of them would want to avoid paying our dues here. Maybe because I'm even surprised we are proposing to remove the corporation tax. But it's a very lucrative business, and you saw what happened with these cases that URA has been handling. It's going to be a similar case. You're going to have companies coming here knowing there is a very lucrative insurance business in the oil industry, because our local companies, they don't have the capacity, so they're going to engage in reinsurance business. So, Madam Chair, I would support the proposal that, one, we retain the option of imprisonment. Then, two, we raise that fine from the current, the proposed 5,000, at least to 10,000, which, because 10,000 is very little money for this kind of business we are talking about. Very little. In the oil industry, Madam Chair, that money is very little.
Honourable members, this provision is that someone who purports to carry on insurance business, reinsurance, or business as HMO in contravention of this act. So you might send people for about a year. You are getting money. You are sending them for a whole year, people don't know that you are a thief. Then you are fined only 200 million. Maybe you have collected the billions from the people of Uganda. Also, Honorable Court has reminded me, and I think Honorable Chris should remember, when we were doing we had a charity walk for the victims of acid. And then the police told us the penalties are so small that people pay fine and nothing happens. That's what the police told us, that the penalties are not serious. They come with their fine, they just pay and go. They go back to start again. Maybe you want to study the quantum. Maybe you want to look at the quantum? Let's stand over it and look at the quantum.
Okay. Madam Chair, I beg that we stand over this clause and the committee finds time to study it further and report back.
Okay, but let's not play with our rights. Okay, stood over. Clause 34 has been 33 has been stood over. 34. With the question that clause 34.
Madam Chairperson, we propose to amend clause 34, subclause 1A, by deleting the words insurers appearing in the last line and substituting the words licensed insurers. Justification to comply with ICP 4 that requires all insurers to be licensed.
Members, question is closed. 34 be amended as proposed. Those in favor say aye, the contrary no. Please have it.
Clause 35 as
35.
amended.
I put the question that clause 34 as amended do stand part of the bill. Those in favor say aye, the contrary no. Please have it. By the honour members, sorry, when the clerk came here, she came to tell me that Honourable Anywa has had a serious accident. Yes. And I've asked her to contact the Inspector General of Police to see whether they can send a helicopter to bring her to Kampala. Honourable Beatrice Anywa. She was going to Kitgum for burial. Yes. Yes, Honourable. 35? 35.
Madam Chair.
Clarification.
Madam Chair.
On
No.
Madam Chair.
But he hasn't moved. He hasn't moved.
Yeah, but this is, maybe I may need your guidance, Madam Speaker. I've been following the proceedings. We're concentrating a lot of powers in a minister. And a minister in this case is just an individual.
Where is that? In clause 35?
Sorry?
In clause 35?
think
We are, he has not even moved close 35.
All right, okay.
Honorable Chair.
Madam Chair, we propose to amend clause 35 as follows. 1, in the head note, by deleting the words Health Insurance Organization, and 2, in subclause 1, by deleting subclause 1 and substituting it with the following. 1, a person proposing to carry on business as a health membership organization shall apply to the authority in a prescribed form for a license, which application shall be considered by the authority. 3, in subclause 2, by A, deleting the words health insurance organizations, and B, inserting the words licensed and. Justification is to remove the mandatory obligation being placed on the authority to grant a license to applicants. The redraft subclause 1 gives the authority the mandate to consider the applications for grant of a license.
Honorable Saida.
Madam Chair, I'm seeking for clarification on the difference in the head note between health insurance organization and health membership organization. I've looked at the interpretation. There is health membership organization, but health insurance organization is not in the interpretation.
Honorable Chair.
Madam Chair, the Honorable is asking the difference between health insurance organization and a health membership organization. The difference here is that the health membership organization will be the one charged with the responsibility of underwriting risks related to health. And Madam Chairperson, I beg for more time to consult on the health insurance organization.
Okay, honorable members, we stand over clause 35. We go to now clause 36.
Clause 36.
Thank you very much, Madam Chair. Maybe you will guide me, Madam Chair. We have these insurance companies, I think I should not even call them insurance companies, who insure these other common vehicles, third-party insurances, and they are everywhere. Every petrol station, you find it. Vehicles pay 30,000, others 70, others 120. It's between that money that they pay. And when you get like an accident, those people can never help you in any way. And I thought that the reason why we go for insurance is to get protected. So if such companies can't protect you, Madam Speaker, why do we give them capacity to keep on operating? And at the end of the day, we don't see what they have done for us. So, Madam Speaker, is it not good that we remove them so that at least our people get to know that if we are going to be insured, really, we should get the service. We go to an insurance company where you sign a contract and be very sure that in case I get an accident, these people will come in and really help me. Otherwise, I've seen our people suffering because the traffic is using this insurance very seriously to bribe people, to put people in prison, to make people stay on the road for the whole day, those who can't manage, because sometimes you find the police is very tricky also in that area. So, Madam Speaker, maybe you can help me understand it. Or if you can allow me, I request that we add some section maybe to remove that kind of insurance companies, which can't help us in case of any problem.
Now, honourable members, I think that kind of insurance is under the Traffic and Road Safety Act. It's under a different law. The motor vehicle insurance is under a different law.
Madam Chairperson, motor vehicle insurance, no, this is different. Let me be specific. Third-party insurance is, first of all, a product which insurance companies sell. However, the laws of Uganda require that every vehicle must have a third-party insurance. And this insurance is not seeking to protect the owner of the vehicle, but it seeks to protect the third party or the passenger in an event that an eventuality occurs.
But I think what Honorable Karunji is saying is that that third party is not protected.
Yes, exactly.
Notwithstanding the payment of that money, the third party has no protection. When they try to claim, that's what she's saying, that when they try to claim, they don't get any.
Madam Chair, I feel the minister is in a better position to respond to that.
But, okay.
So as the chair has said, if you go and buy a third party from an insurance, and in case of any incident, you are supposed to go to the insurer and make a claim. So, Madam Chair, I don't think that there is an insurance which will refuse a claim which is genuine. So I don't know whether this is an issue of awareness or an issue of refusal by the insurers. I don't think so. So, Madam Chair, I can have a bilateral with my sister from Kanungu to get to understand what she's really meaning.
Madam.
Because if you get, yes?
Madam.
Yes, Honorable Genesi.
Madam Chair, I would like to get a clarification. I was personally driving my car a few years ago with a passenger. We had a small problem. The passenger went to the insurance company to ask for some compensation. They just ignored him. And my other challenge, different insurance companies charge different prices at different stations. You go to Shell, you pay a different price. You go to Cartex, a different price, the same vehicle. So my clarification is, really, does it really serve the purpose? Thank you.
Maybe, I don't know whether...
Information, Madam Speaker. Madam Chair. This issue of third-party insurance, normally what happens is that once an accident has occurred, you don't just go to the third-party insurance people. First of all, you must go to the police, you must get a police report, and you use this police report to go and get your claims. So maybe it could happen that once the accident happens and somebody goes, but I think for me as an individual, I've benefited from that. When an accident occurred, went to the police and asked how I can best be helped. They wrote a report. with also a letter which I took to these people. So maybe that could be the
Information.
procedure to be followed.
Madam
It was third
Speak-
party.
Thank you. Madam Speaker, I think maybe the colleague did not understand exactly what I meant. There are people who are giving us third-party insurances, and there are other insurance companies where we sign. For instance, one time when we were going to Chankwanzi, Honorable Aja got an accident. So his kind of insurance, maybe it could be like for the other honorable, which he doesn't pay the 30,000 or the 70. So the one I'm meaning is this one we just meet on the way, and which police considers, by the way. The one you are talking about, maybe you had made a good agreement with them, like Honorable Aja had done, and so they had to compensate. But Madam Speaker, I've also ever got an accident, and I tried to follow up myself, and they never helped me. And I've got many testimonies from many people, even these members of parliament can testify that those third-party insurances we find at petrol stations, which the police always consider very much, are not helping our people. So,
Okay,
Madam
let's
Speaker, I would pray that I move that we add there the section to say that those kind of third parties, where somebody doesn't make an agreement with the insurer, should be removed. We expunge them because you can imagine, Madam Speaker, somebody having a business, but because he has not insured his vehicle of only 40,000 shillings, he stays on the road for the whole day and everything fails. And sometimes people have problems, they fail to even raise 90 when that insurance has expired, and it causes him to sit at home for a whole week. So, Madam Speaker, I think it would be good we include a section here to remove all those kind of insurance companies where you don't sign any kind of agreement, to certify that you have an agreement with the insurance company, and in case of anything, they will help you. Thank you, Madam
Let's
Speaker.
ask the Secretary Minister. Let's ask the Secretary Minister.
Madam Speaker,
Yes, Honorable Singh.
Thank you. You are now chairperson. Thank you,
That's why this
Madam
one is here.
Chairperson. Now, may we request that the minister presents us with a report detailing the performance of this third-party insurance scheme, because we've been paying money over the years, but we don't know where this money goes, and we've not seen people that have benefited from such money that we pay. So we would require that the minister can give us a report on the performance of this scheme over the last 5 years or even 10, because people have always been paying and nothing has happened. I thank you, Madam Chair.
Thank you, Madam Chair and honorable colleagues. Yes, it's true that in some cases third parties have low limits. In other words, when you get into problems, how much they can compensate you, but also the issues that have been raised by Honorable Kalunji. But that part that we are discussing here is under a different law, the Motor Insurance Third-Party Risks 1988, and it's being reviewed for amendment. So it will be appropriate that all those amendments that members would want to suggest are really handled under that law. Otherwise, if we mix it with this one, we have not studied it, it can confuse us. So I can pledge that that amendment can be fast-tracked and brought to the House so that those concerns are addressed.
Honorable Sengo, you know we're in the committee now. I think when we resume the House at a convenient session, you can move formally that motion to get an account of the performance of the third party. But it's important. We've been paying for a long time. I think we need to know, is it working, is it not working? Thank you. So,
Madam Chair.
So your proposal will have to wait for the amendment, but we can discuss it. When his motion comes, we can discuss the performance of the third party while waiting for the law. Now, let's...
Madam Chair, I just need some simple clarification.
on-
Because if you read this amendment,
Which one? Clarification on what?
that is 35 to...
No. We have stood over it. We are not discussing it. We are on 36 now. You'll discuss when we come back to it. 36? I put the question that was... there's some
Madam Chair,
amendment.
36. We propose to amend clause 36 as follows. By deleting sub-clause 1 and substituting it with the following. A licensed insurer and an HMO shall have and maintain paid-up capital of not less than the amount prescribed in the regulations. 2, by deleting sub-clause 2. 3, in sub-clause 3, by deleting the words directs otherwise and substituting the words otherwise approves in writing. And 4, by deleting sub-clause 4. Justification. Madam Chair, the details of the requirements to be paid in relation to the capital requirements of the insurance companies should be provided for in the regulations.
Now, can I know from the Minister the rationale for the amount, the quantum?
I can. Madam Chair, why we are providing that we shift this, the ceilings in the amounts or the specifications, is that over time, these amounts keep changing, and we wouldn't want to come back to Parliament every now and then seeking for amendment when this so happens.
So you can change it in the regulations?
Yes.
Yes, Mwabuzu?
I would like to propose that we amend it in such a way you bring the new tariff structure to, late in Parliament, probably before it is operational, because there can be a chance that an overzealous person may just set up outrageous amounts and then start to operationalize them. If there was a mechanism through which you lay in Parliament, then Parliament has input before it becomes operational, I would buy such a proposal.
Thank you, Madam Chair, and thank you, Honourable Member, for the concern. However, Madam Chair, to guard against his concern, I am made to understand that all regulations are approved by Cabinet, and therefore that provides a safeguard. Parliament doesn't approve regulations.
Clarification, Madam
No, we
Speaker.
don't.
Madam Chair. No, thank you, Madam Chair. Mr. Chair, this is going to serve as a tool. This bill is going to serve as a tool when it becomes an act. And you know, there is what we call investment confidence. Especially multinational or big companies when they want to explore business prospects in Uganda. Some of these are the things that they'll be paying particular attention to. And at this point in time, Madam Chair, I would suggest that, or propose that we don't just make an open space for, as far as the money is concerned. And as a result, I was proposing, Madam Speaker, Madam Chair, that A, B, C, and D, we stay the figures, but also for investment confidence, we're instilling confidence in prospective investors, we triple. No one really is going to stake their monies in a country that is, has an environment that could be prone to manipulation. And because what you've just said, that the regulation might result from government, that does not deter us to put a standard figure upon which the regulation would stand. Thank you.
Honorable Saida wanted to say something.
Thank you very much, Madam Chair. Madam Chair, I support the proposal by the chairperson. Because absolute amounts are subject to variations according to time value of money. And that will require them to come back to this house every so often to raise or to lower the amount. And Madam Chair, that goes with sub-clause 4, where they have provided for a 5% of the profits to be paid up capital of the insurer to facilitate capital-based growth. Madam Chair, I have a problem with this. Because if the inflation is higher than 5%, this will not be able to promote capital-based growth. And what I would like to propose in this sub-clause 4 is that we put a markup on the prevailing inflation rate such that the amounts don't go below the inflation.
Remember, I think I also agree that we should not fix the sum. Under the penal code, the fine for adultery is still 600 shillings. It has never changed. It must be like 30 years ago when it was imposed. 600 shillings for adultery. Yes. So, honourable members, the question is that clause 36 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 36 as amended.
Put the question that clause 36 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause.
Now, honourable members, before we proceed, we have in the gallery a delegation from St. Augustine Community Program from Wisconsin in the USA. We have Dr. Daniel Johnson. Will you stand up? It's here. It's not them. Dr. Johnson? No? James Kirk? Yes, there he is. Jeremiah Rin? Patrick Pellman? Welcome. Jonathan, and also there's Jonathan Kirk. They support Zombo and Nebi districts. They support women groups and provide scholarships. They are here courtesy of Honorable Kata Anyorach of Padiere. You're welcome. So let's go to 37. Clause 37, Honorable Chair.
Clause 37, Madam Chair, we propose to amend it as follows. By deleting the words financial institution in sub-clause 1 and substituting the words a commercial bank approved by the authority. Justification is to be more specific and ensure accounts are opened in Class A banks.
Honourable members, the question is that clause 37 be amended as proposed. Those in favour say
Chair.
Yes, Honourable Saida.
We've had banks collapsing every other day. Crane Bank had won awards so many times, and nobody expected them expected the Green Bank to collapse. I'm a bit uncomfortable if we just say with a commercial bank. Because what protection do we have against the collapsing banks? I don't know where, but there is some discomfort which I would like to be chewed before I accept, before personally I feel comfortable with this clause.
What do you propose, Honorable Saida? What do you propose? Yes, Honorable Saida.
Yeah, Madam Chair, I would be comfortable if these deposits were guaranteed by the central bank, such that even if the bank collapses, they will be able to get 100% to meet customers' claims.
I think because it says commercial bank approved by the authority, but I think she wants to give the, you want the central bank to recommend or what? To recommend the bank? Minister, what do you say about? But of course, if they're going to open an account, the authority will have to agree to it, isn't it? Hmm? It's okay? Can we stand over it?
Madam Chair, maybe the honourable member can first.
Thank you very much, Madam Chair. Actually, Madam Chair, I would encourage the House to adopt Honorable Saida's Bumba's proposal. The proposal is that instead of, we substitute the Bank of Uganda or the central bank, because I think it is the chief regulator. Sorry?
But, honourable members, I think you are trying to address 37.3, isn't it? On the deposits. Isn't it? Because it's the authority which must decide. It is a decision of the authority to say we take it to we invest in this, in government securities, or in other, it's the board, the authority which decides what to invest in.
Madam Chair, thank you for your analysis. But I think she helped us to get the background of where she was coming from. That certainly we can't just place this in the hands of a commercial bank. And the economic trends globally, we cannot, I think we're not in a position as a House to determine which bank will collapse tomorrow. And I think this is, her proposal is basically supposed to give a prescription to this,
Minister, can you
to 37.1.
You want them to buy treasury bills and this and that? I don't know.
Madam Chairperson, if I may read verbatim, clause 37.1 reads as follows. Every insurer shall hold an account maintained by the insurer with a financial institution of a sum equal to 10% of the paid-up capital of the insurer. Madam Chair, in our view, a financial institution can mean a commercial bank. Basically, what this is providing for is a commercial bank. But we thought that to be more specific, instead of using the word financial institution, we use the word commercial bank. And also, when you read 3, the worries which Honorable Saida Bumba has, Madam Chairperson, the worries which Honorable Saida Bumba has can be protected under 3, which reads that the deposits made under subsection 1 shall be invested by the insurer in government securities or any other investment as may be approved by the authority. Madam Chair, in my opinion, I don't see anything wrong with Parliament adopting our proposal, because after all, it is just seeking to make the provision clear. It is not substantially changing anything much.
But also, can an insurer hold an account in the central bank?
No.
So it has to be a commercial bank?
Yes.
It has to be a commercial bank?
Madam Chair. Information.
Carter. Okay, Carter, and then Oshava, then here, then one.
I think, Madam Chair, the proposed amendment is chronically misleading. The position in 37, as it is in the bill, is more convincing, so that it does away with the fear that people have with commercial bank. When you talk of financial institution, Madam Chair, we passed a law here where we're talking about Tier 4 microfinance institutions with even big capacity to even hold deposits. We're talking about like Wazalendo of the Army. If, for example, the Army started insurance services and they become insurer, we don't need to limit them that they can't hold their money is 10% of their paid up capital with their own Tier 4 microfinance institution, which is so powerful. So, in other words, to drag us to really lock us to commercial bank is more disastrous. The position as it is here is...
Clarification.
Let me finish.
Just a small clarification to help me. Honorable Member, thank you very much. Are you saying that it is safer for depositors to put their money in a circle rather than a commercial bank? Is that what you are doing?
Actually, as it stands now, if we use Uganda's situation now, where we are almost in economic recession, it's even now more dangerous to trust the commercial banks. Because if I'm with the circles, I'm even part and parcel of the circles. I am holding probably shares with them. I'm everyday part of the management. I can be in charge of what we call internal law insider lending, which the management was doing at a Crane Bank. We can stop it before we allow it to continue, because I'm a member of it. So anyway, that said and done, for me, what I would love to say, Madam Chair, is that if we leave it as financial institution, the greater includes the lesser. Meaning, if by the decision of probably the board of the insurers and so on, or any other decision, members would want their accounts even to be held at Uganda Development Bank, so be it, depending on the arrangement. So why are we looking into commercial banks? I think, right, Honorable Chair.
I think there's another problem. Honorable Chair, your proposal is that it should be approved by the authority. So if I'm an insurer and I want to open an account in Equity Bank, the authority will say, no, don't go to Equity Bank, you go to DFCU. That's what you're proposing here. With approval. If they don't approve, what happened? Do you still go to Equity? Honorable Shava, you want to say something? Then Kaberuka.
Thank you very much, Madam Chair. I think we should avoid the two extremes. When we are legislating today, we shouldn't put the current economic trends and say that because of what happened to Crane Bank yesterday, is what will happen 10 years to come. The law we are creating is a law that will be for this country even much more. So I wouldn't agree with somebody who says that we should put a demand that they open up an account in the central bank. Neither will I agree to leave it open to every financial institution. Therefore, I will support the chair. We limit the money they should open up accounts in commercial banks. Madam Chair, when we leave it to open to financial institutions, even my Karwana Sacco down there will be open to do that. So I want to suggest that we support the chair in his proposal, that we maintain this to commercial banks. Thank you so much.
My question is, do I need the approval of the authority to open that account? Because that's what you are proposing here.
It's the security deposit, Madam Chair.
So the authority should
Has to guide you where the money is.
Yes.
Thank you, Madam Chair. Madam Chair, the word financial institution is more generic. Is more generic, and it includes my circle in my village. Madam Chair, to be particular and specific, I think commercial institutions, commercial banks will be verified by the authority, and will take the advice to the insurer, such that they also take part. But also, when we consider in a financial institution, Madam Chair, we shall be leaving it, to many various institutions which are weak. But it is the central bank who will be responsible, to control the quality of the commercial banks. But really, financial institutions are more generic and weaker than commercial banks. So I would propose that we go by the proposal and hold the commercial bank, and the authority is to control and to be part and parcel of that decision that is made of that bank, that will ensure that 10% of the people's premiums. Thank you.
Honourable members, the question is that clause 37 be amended as proposed. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 37 as amended.
The question is that clause 37 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 38.
Honourable members, just to update you, the Honourable Banya will be flown to Kampala tomorrow. She's now in Gulu. The Inspector General is in touch with her, and they'll bring her in the morning by air from Gulu. They didn't tell me, just said. Okay, 38, Honourable Chair.
38, Madam Chair, we propose to amend it as follows. 1, by inserting the words OHMO immediately after the word insurer wherever it appears. In subclause 1, by deleting the words in the following priority and substituting with the word solely. In subclause 1, by deleting the words in the following priority and substituting it with the word solely. 3, in subclause 1b, by deleting the words with any remedial measures or enforcement powers exercised by the authority in relation to the insurer. 4, by deleting subclause 2 and substituting it with the following. A security deposit, A, shall be dealt with in accordance with the written directions of the authority, and B, shall not be released except with the written permission of the authority. Justification. HMOs are also required to make security deposits and to provide clarity to the clause by drafting sub-clause 2 better.
Honourable members, you've heard the proposals for clause 38. The question is that clause 38 be amended as proposed. Those in favour? What is so wide?
Madam Chair, I think the justification that is given for 4, that is on 2, where it's talking of an insurer that holds a security deposit and is proposing that we should delete clause 2 and substituting the following: a security deposit. The whole of clause what? Clause 2. Is it fully deleted? Subclause 2, sorry. 38, subclause 2. It's not very clear. 4. Chair, by deleting subclause 2 and substituting the following: a security deposit, A, shall be dealt with in accordance, because in the bill it says an insurer that holds a security deposit shall deal with the funds deposited. Madam Chair, in legislative drafting, you can't put a deposit shall be dealt with this way and so on. If it is not dealt with, then who is held accountable? You must first put someone who is going to be held accountable. Then you say, for example, the word actually SCT is in the bill: an insurer that holds a security deposit shall deal with the funds, shall do this. But when you're putting it general and saying now, a security deposit, as you're proposing here, shall be dealt with in accordance with the written directions of the authority. If it is not dealt with in accordance with the written directive of the authority, who is held accountable? So it becomes vague in legislative drafting. Actually, the terminology SCT is, the format SCT is in the original, is more clear. Yeah, it should remain as it is. That's what I'm saying. That's what I'm struggling to say.
No, Honorable Chair, I don't know, you know, this 38(1)A, I think they were setting up, if you have $100,000, the first priority, if you have it, is to pay the insurance claims. If there's a balance, you go to 2. If there's but when you say solely, now, I don't know that it's just paying the insurance claims, because this is presenting a hierarchy of what you should satisfy in 1A. It's giving a hierarchy. First, if there is a deposit, first pay the insurance claims. If there's a balance, then you can do the costs associated with this and that and all these others. But when you say solely, it means insurance claim.
I think I agree with you that the original formulation of the clause was better than this one, because solely is very confusing.
But once you pay the insurance claim, you can't touch it anymore.
Yes,
Because you have
so-
said you just pay the insurance claim. That's
Mr. Chair, why
that's what
can't
you're
we
saying.
maintain
Can
the
you
original?
revert to the old position?
Madam Chairperson, if I may recall where we picked this from, in the Companies Act, there is a provision of how claims are settled in an event that the company collapses. While in insurance, while insurance claims do not fall under the priority creditors, and our proposal is seeking to make insurance claims one of the priority claims to be settled in an event of loss.
What is the order of precedence for those settlements? What is the order of precedence? What you are justifying the original formulation, that the insurance claims take precedence over the others.
Yes, that is what we,
But that's what the old law is saying.
okay, if that is what the old law is saying, then I concede.
I think you're better off retaining the old one because it sets the hierarchy.
Okay.
What you pay first, what you pay next, what you pay next.
Then, Madam Chair, I concede.
Okay, thank you very much. Honorable Omate.
Thank you, Madam Chair. Madam Chair, I'm a member of the Finance Committee. But I feel that this committee, this bill is so fundamental to the operations of businesses in Kampala, in Uganda, and the insurance industry that is so crucial to the to spurring of the economy. Right, Honorable Speakers, you are, Madam Chairperson, there are so many activities this afternoon, and that's why members of Parliament are not in the House. Some of them, of course, traveled to go and bury the husband of one of our colleagues. Madam Chairperson, would it not be procedurally correct to defer this bill to a date when at least we have reasonable numbers of members in the House? I beg to submit, Madam Chairperson, so as to do it justice.
Okay, honourable members, let me invite the Minister to move for resumption of the House.
Madam Chair and honorable colleagues, I beg to move that the House do resume and the Committee of the Whole House reports thereto.
Honourable members, the question is that the House do resume and the Committee of the Whole House do report thereto. Those in favour say aye, the contrary no. Let's have it.
Report from the Committee of the Whole House.
Honourable Minister.
Madam Speaker and honorable colleagues, I beg to report that the Committee of the Whole House has considered the bill entitled the Insurance Bill 2016 and
Where are they? Yes, proceed, Minister.
and considered part of the bill up to clause 37 and stood over clause 2, 25, 28, 23 and no, clause 2, 25, 28, 33 and 35. I beg to report.
Okay.
Motion for adoption of the report from the committee.
Minister.
Madam Speaker, I beg to move that the report from the Committee of the Whole House be adopted.
Honourable members, the question is that the report of the Committee of the Whole House be adopted. Those in favour say aye, the contrary no. Let's have it. Honourable members, apparently while we are busy, the There were pupils and teachers of Nyize Primary School in Kangulumbira, Kayunga District, represented by Honorable Vaseke and Honorable Nantaba, but I was not told, but I think let's have it for the record that the children came here to observe the proceedings. Now, I wanted to remind the government that by the 15th of March, you are required to have presented all your policy statements. 15th of March. So please do the needful. Now, otherwise, House adjourned to Tuesday next week, 2 p.m.